It's adjourned. So for here of the very well. How about you? Okay. Fourth. So the application of learned counsel is granted without any objection, and the court orders are spread on the motion paper. Meanwhile, the matter is adjourned to the 24th day of February 2026 for hearing of the motions before the court. Yes. Very well. Yes. Okay.
Actually, that's not on the week.
Okay.
It's not going on.
Okay.
Have it adjourned before the court because of the history of this man.
Okay.
I would have gone after the court very early when I was informed by the council for the payment that they won't be found.
Okay. Okay.
This is a matter that
You didn't want there to be given off records. Okay. Number what?
number 8.
Oh. Number 8 is Mr. Eh? Okay. Florence Adebayo.
Yes, ma'am.
Okay. So call it up. I will adjourn it and take the judgment.
Okay.
I don't know if those for judgment are here.
Housing and urban development. Who wants to represent the dependent housing?
Okay. By who?
Olaoluwa Adebayo. Your position. The relationship is first son, my lord.
First son.
Of claimant.
Okay, and the defendants are okay. Yes. Appearances. Yes. Okay, please speak up. Why don't you come to where there's don't you want to be a son? So so your name, please. Yes. Holding the brief of. Okay. Okay. Dekunle Ojo. For the claimants. Yes. Yes.
Station ZID. Lord appear for the 4th defendant.
Yes.
But the matter for today is the continuation of hearing.
Okay.
Unfortunately, I was in this court that my little friend for the claimant informed me
Okay.
that he wouldn't be coming when he called his junior and giving the phone, and that he would letter of to us, new information, and got the answer. Hello. it grips my heart because of the age of this matter. The age of this matter is what we have today and January. And ordinarily, if the listener had come here, he would have put his second witness in the box.
Okay.
And then their whole part of the case would have been over.
Okay.
January will put our own defense and counterclaim.
And before we know it,
the 1st January, next don't take. And if the court can give us yet another date, doesn't matter if it's in March, February, March, so that we can have 2 dates. Because I know now that the court has moved over to March, and January, the court will be moving over to April, May. And we are really.
okay. Can we give them another date, please?
March 26th.
Oh, you took the March. Is it because you said March? Okay, 26th March. How do you start?
January, February, not because of the.
Have a date for January already.
Since we can take a strong date in February.
If we have a February date, we give them. It's a very old case. Okay.
Very much.
When? It's not 15. How do you stand on the 17th day of March? Okay.
Not an earlier date in time. 17 is the earliest
March 10.
Okay, March 10 is not coming.
Okay. It's convenient. Okay. We are taking tomorrow. Are we? 21st. Okay, 21st. So this matter now is adjourned to the 21st day of January 2026 and also the 4th of March 2026. Yes. Yes, and that it will be for continuation of hearing. Yes. Thank you very much. I wish you the same of hearing. Yeah. 10, 12, 25. Yes. Number 9, Lagos State University, Mr. Baje. Okay, number 12 in my. Which one? The Ignatius Oguche. Of hearing, yes. Please. What of this? Okay. What of the judgment?
Okay, the judgment.
Okay. Okay. That's all right. Council. Let me tell you. They caught to quickly. Sorry. This council. You say yours is number Ignatius Okuche.
Yes, hello.
Yes, we shall take it after we've taken this. There's a little judgment. Okay. Okay. On the other side.
that left for the court might decide whether to grant fair or continue or not. The court decides to go to that, it's not going to traffic, then we go ahead. But we can't go ahead, what is the motion? For say, whether the motion is there, we can't take money because that's traffic record. That motion is there. But say, please and father, we traffic record. And tell the record. What is
That one. Okay, let me. Okay. Okay. Do you confirm what you said?
Yes.
And we're not, their rights to our for.
You're right.
So, yes, we're served with purpose of appeal.
Okay.
Uncertified. No uncertified.
And you're taking it.
But I think that appears they compiled by themselves, not the registry. So there is no certification that this manuscript from the registry has the correctness or genuineness of that work. So this morning the rules are clear. We're not even started because the rules are clear as what the court will do. What will satisfy the court is state proceeding. Not just mere filing notes about the participation. The rules are clear on what will happen before the court can state proceeding. So if the matter is court and address the court and if the court is of the opinion that for the state proceeding, then we are ready to proceed. I also asked the counsel outside, is there any prejudice that we, the claimant, who have opened our case since 2023, for us to examine today and we close our case? Since what's the appealing for? Is that he was denied funding an additional witness from his defense, not even for the claimant. So there is no prejudice in anything. I told you.
Anyway, I don't know if you're aware that recently courts of appeal frown on interlocutory appeals. What they usually do is you will see when you go there, they'll tell you to go downstairs, finish everything. If you fail, you come on appeal, we trash it out for you. If you succeed, if we don't see you, that's all right. That is the trend now, but I will not stop anybody from doing what he wants to do. Yes. I think what we just do is for my registrars to give you a convenient date.
So we're going to take a day. My wish I will ask you first because the claimant is here and we're ready to proceed today. I mean, we shall be doing that because if they wanted to compile and they're not even showing any evidence that this has happened, why we will stay in the proceeding? These rules are clear.
Well, if I were to hear him, I will insist on. Counsel, it's easy for you to say, let's be heard. You don't understand. Please. Okay, we shall look into it. Call the matter for judgment. I'm sure they must have been here for a long time.
Love Power and 72 others, and United Bank for Africa PLC. Other parties are absent.
Appearances. Yes. Okay. Adela, your surname again? Okay, okay. Yes. Okay. For the claimants. And these 73 people are the claimants. Okay. Yes. Yes.
and it's spelled HALPEM
Okay.
for the defendant.
In the morning, I said I will start from the beginning and just end at the end. But here, please, I may not take all that has been written down. Yes, because some people are still here, and we're even having Zoom trial today. Now, this suit was instituted by the claimant via a general form of complaint dated and filed on the 10th of March, 2021, asking for the following reliefs. A declaration that the restriction and subsequent detention of the claimants in their various offices from 5 p.m. to 11 p.m. on the 3rd day of January 2020, whereby they were forced to write resignation letters, is wrongful and against fair labor practice. 2, a declaration that non-payment of gratuity to these claimants who have served the defendant for a period of 10 years or more, as specified in the claimant's offer of employment letter, is wrongful and constitutes a breach of agreement on the part of the defendant. C is a declaration that the non-remittance of pension contributions of some claimants to a pension fund administrator is wrongful and illegal. D, a declaration that the non-remittance of the deductions of the claimant's contributions to the National Housing Loan Fund is wrongful and illegal. E, an order compelling the defendant to remit the claimant's deductions of the National Housing Fund to the claimant's accounts with National Housing Fund. F, an order directing the defendant to pay to the claimants the sum of 37,477,888 naira 70 kobo as gratuity owed the claimants who have served the defendant for a period of 10 years or more. G, an order directing the defendant to pay the claimants the sum of 649,190 naira 39 kobo, being the total sum of unremitted pension contributions of the claimants. H, an order directing the defendant to pay the claimants the sum of 3 billion naira as general damages for the trauma suffered by the claimants arising from forceful resignation and detention in their offices from 5 p.m. to 11 p.m. on the 3rd day of January 2020. I, an order directing the defendant to pay the claimants their individual claims in paragraph 16 of the statement of facts, being the sum total in paragraph 18, E to I. J, the sum of 20 million naira being the cost of this action. Well, summary of the claimant's statement of facts. The gist of the claimant's statement of fact is that all the claimants were in the employment of the defendant until the 3rd day of January 2010, when they were forced to resign. On the 3rd of January 2010, the claimants who worked in the